everyone, I am Vibha Chauhan and welcome to Chauhan's Classes Funda Clear. So today I will explain chapter 7 from the Indian Polity book written by M Laxmikanth, and the chapter is Fundamental Rights. So this is the second part of this chapter. In the first part of this chapter I have already discussed from Article 12 to Article 22. So let's continue with our third fundamental right, that is right against exploitation. Right against exploitation, that is our third fundamental right, and it covers from Article 23 to Article 24. And our first subtopic in this is prohibition of traffic in human beings and forced labors. Prohibition of traffic in human beings and forced labor. So this is Article 23. Article 23 prohibits traffic in human beings, begar and other form of forced labor. Now any offense of this provision will be considered as an offense and will be, you can say that, will be taken with accordance with law. So you can say that Article 23 prohibits all type of forced labor, all types of traffic in human beings. The expression traffic in human beings means that traffic in human beings, that is buying and selling of men, women, children like goods, or it can be immoral traffic in women and children, and including prostitution. It also includes prostitutions, devdasis and slavery. So you can say that the expression traffic with human beings, you can say that is a vital expression and it prohibits all types of traffic in human beings. And the term begar means forced labor. Forced labor means that you are forcing any person to do work against his will, and it prohibits all types of forced labor. Article 23 prohibits all types of forced labor, and it also, you can say that, other types of forced labor like bonded labor. And for this, the parliament has enacted many laws. For example, you can say that Traffic in Human Beings Prohibition Act. There are many acts enacted, you can say that, to prohibit these practices, you can say that. So you can say that Article 23 prohibits in traffic with human beings, forced labor, begar, that is, and other forms of forced labor. And here force isn't only physically, you can say that, isn't just physical force, it is also the compulsion, you can say that, of work due to economic arises, you can say that. For example, a person is working in a very, you can say, the low wages. So you can say that here force doesn't mean only physically, or you can say that only liberally, but it also means by economic reasons. So you can say that this Article 23 prohibits all types of traffic with human beings and forced labor. But there is one exception, that is the state is bounded to, you can say that, to impose, you can say that, any work. For example, military services, it can ask for voluntary services for military services without any, you can say that, payment, without any, you can say that, wage, because if there is an emergency for people, then the state is bound. State can, you can say that, state can ask for military services from people and it is not bound to pay for it. And but there is also one thing, that state cannot discriminate only on grounds of, you can say that, race, religion, caste. That is, it is asking for only particular religion or particular race or particular caste. That cannot do state. So you can say that Article 23 prohibits traffic in human beings, begar and other forms of forced labor, but it can ask for voluntary services for state. State can ask for voluntary services. And next is prohibition of employment of children in factories, etc. Prohibition of children in factories, etc. So Article 24 of our Indian Constitution says that prohibits, you can say that, prohibits children employment below the age of 14 years in hazardous factories, mines, you can say that. It prohibits in all hazardous, like railway, at construction sites, at mines. It prohibits all, you can say that, children employment below the age of 14 years. It can be above the age of 14 years but not below the age of 14 years. And the most important act enacted for do this, the enacted most important act in this direction is that you can say that Child Labor Prohibition and Regulation Act, that is CLPR, Child Labor Prohibition Regulation Act, and of 1986. It was enacted in 1986, and after that for children employment, for children improvement, there have been done so many things, you can say that. For example, National Commission and state commissions for children improvement, you can say that have been enacted, have been appointed, and the children courts are also providing for a speedy trial of offence against with children or a violation of children's right. So you can say that for child improvement, for child education, for better child education, for better child nutrition, for better child improvement, there have been done so many things. And in 2006, the government also banned children employment as a domestic worker or worker in. And in 2006, the Parliament also banned the child employment as a worker, as a domestic worker, or as a worker in business establishment like in shops, tea shops mainly, dhabas, restaurants, hotels, and so on. There cannot be children employment under the age of 14. And if anything has been found, if any offending employer has been found, then he has to pay 20,000 rupees for each children employed. So you can say that for each children the fine is of 20,000 rupees. So you can say that Article 24 prohibits children employment below the age of 14. And here what you can relate with? You can relate it with, you can say that right to education, because there also it is that for 14 years. So you can say that below the age of 14 years there cannot be any child employment. So next fundamental right is freedom of religion. Freedom of religion, that covers from Article 25 to Article 28, and in this our first is freedom of conscience and free profession, practice and propagation of religion. So freedom of conscience, free profession, free propagation. So Article 25 entitles to all persons equally freedom of conscience and free profession, religion, you can say that, and propagate. So every person has right freedom of conscience, that is inner, you can say that inner freedom to mold his relations with God or Supreme as any way he desires. And next is freedom of profession. Freedom of profession, that means you can say that he can freely declare his beliefs, faith of anything. You can say that his religious beliefs, faith openly. He can declare his beliefs, religious things openly and fairly, freely, you can say that. Next is freedom of practice, that is he can practice his ceremonies, religious ceremonies, exhibitions. He can open religious exhibition. He can practice his religious, you can say that, religious beliefs, religious rituals that are called as religious practices, rituals. He can do rituals freely, freedom. He has freedom to do this. Every person has freedom to do this. And next and last is freedom of propagation. Freedom of propagation is that he has transmission. He has freedom to transmission of his religion and dissemination of his religion. That is, you can say that exposition of his religion to other person. But this doesn't cover that you declare, you can say that you convert that person, other person, to your own religion forcibly. It doesn't cover that right. So you can say that because every person has his own right, freedom of conscience, so you cannot force any other person to convert into your own religion. So you can say that Article 25 provides for freedom of religion of individuals, and it also provides for freedom of religious doctrines, that are doctrines, and as well as religion, as well as rituals of religion beliefs, faith that are. So you can say that Article 25 is for that. And here you can say that there is two exceptions, that are, first is that the state is empowered to, you can say that, regulate prohibit or restrict any economic, you can say that economic or political, you can say that religion. So you can say that political, religion, beliefs, faiths, you can say that state is empowered to do this. And second is that it is empowered, the state is empowered to make, you can say that, to make a reform in this, you can say that through open Hindu sections, you can say that. And here Hindu does include many things, many religion that are Hindu, Sikhs, Jains, other than Muslims. Here Hindu includes every religion, you can say that. And there is one more freedom, that is every Sikh religion, every person of Sikh religion has right to carry kirpans. Kirpans, as you know, that is their religious belief. So they are, you can say that they are freely to, you can say that, to carry kirpans in their assemblies, in their ceremonies, in their religious ceremonies, and as well as without ceremonies as well. They are freedom, they have freedom to do this. It will not be, you can say that, as offense in accordance with law. But if their intention is wrong, then it can be. Their intention should not be, must not be, to harm anyone else. So you can say that Article 25 provides for freedom of individual's religion. He has right to propagate profession, free profession, and to freedom of conscience. So next is freedom to manage religious affairs. Freedom to manage religious affairs. So we have discussed it, Article 25. Now comes Article 26, that says every religious denominations or sections or community or body should have these rights, that are, first is that they can make their denominations. So second is that they can manage their own religious matters by their own. Third is that they can acquire or own any movable or immovable property and can administer them as well. It depends on them, they can administer them as well. So these are rights that are conferred to any religious denominations. And in Article 25 we have studied that those rights were for individuals, for particular individuals of religions. But Article 26 provides for whole community, whole denomination of religion. So you can say that Article 25 is for individuals, for only individuals, and Article 26 is for whole denomination. And the Supreme Court held that any religion denominations must satisfy these three conditions to say that they are religious denomination. And those conditions are, first is that they all persons should have a common, one religion doctrine, a religious beliefs, common religion beliefs to the conducive of their spiritual well-being. And second is that they all should have a common community, a common organization. Third is that the community, the organization should have a distinctive name, it should be designated with a distinctive name. So from these criteria you can say that any community like Ram Krishna Mission or Ananda Marg are a religious community, religious organization. But on the other hand, the Aurobindo Society is not a religious community. So Article 25 is for individuals and Article 26 is for whole denomination. But they are subjected to the same things, that are public order, morality or health. If they are violating these things, then they are also violating fundamental rights. So for this they would be restricted, they would be subjected to these things, public order, morality or health. So next is freedom from taxation for promotion of religion. Freedom from taxation for promotion of religion. So Article 27 provides that any person must not be compelled to pay any taxes for maintenance or propagating his religion. So if he is spreading his religion or propagating his religion or maintaining his religion denomination or a particular religion, then he is not bounded to pay tax. And because the state cannot use the public money that is that is collected for the promotion of a religion. So that's why any person cannot be compelled to pay tax on a levy for their promotion of religion. But there is a fee. Fee can be collected by them, because fees purpose, the collection of fees purpose is for their own safety, is for their own services. So tax cannot be collected, but a fee can be collected by them even if they are promoting their religion or propagating their religion. So after this, you can say that any person cannot be expelled, compelled to pay tax, but can be paid, you can say that fees, and a fee can be collected on pilgrims for their own safety measures, or in any expenditure, in any meeting they can be collected of fees, there can be collection of fees. So Article 27 is for freedom from taxation for religion, but not for freedom of fee for religion. So next is freedom from attending religious instruction. Freedom from attending religious instruction. So we have discussed Article 27. Now comes Article 28 that distinguishes educational institution into four types. First is that are wholly, that are completely controlled by the state, and in those educational institutions there is no, you can say that, religious things. There would not be any religious attendings, there would not be any religious assemblies. And second is that they are controlled by state, but were built under endowments or trust, and in those the religious assemblies are permitted. Person has to attend those religious, you can say that, those religious assemblies. And third is that any educational institution that is aided by state, and in those institutions it is based on a voluntary basis. It is a choice of person. If he wants to join that religion assembly, then he can, but if he doesn't, then he cannot be compelled to pay attention to that religion assembly. So if it is the educational institution is aided by state, whether completely or half, then it is not, it is based on voluntary basis. But what if a child, if there is a minor child, in case of minor child the consent of his guardian is needed. If there is a guardian, that minor child's guardian's consent is needed. And fourth type of educational institutions that is distinguished by Article 28 is that is recognized by state. Any educational institution that is recognized by state is based on voluntary basis. That is, there is religion assemblies, but the consent of person is needed. It is his choice whether he wants to join or not. And in case of minor child, his guardian's consent is needed. So in Article 28, in the religion, in basis of religion assemblies, Article 28 distinguishes institutions in four types, and in those four types it is that whether there would be religious assemblies or not. In wholly completely received, wholly completely controlled by state, there is no religion assemblies permitted. So Article 28 is for freedom from attending religion. Freedom from attending religion, it is concerned, it is given to every person, whether citizen or non-citizen. So next fundamental right is cultural and educational rights. Cultural and educational right, and that is our fifth fundamental right, and that covers article from 29 to 30. And in this, our first is protection of interest of minorities. Protection of interests of minorities. So this is Article 29. Article 29 says that any section of citizens that is residing in any part of India that has its own distinctive culture, language, script, tradition shall have right to conserve them, to preserve them, and to continue with them. So Article 29, this is the first provision of Article 29, and the second provision of Article 29 says that any person from those section of citizens, from those community of sections of citizens of distinctive language, culture, tradition shall have right to be administered, to have admission in any educational institutions. They have right to have admission in any educational institution. They shall not be discriminated against only on grounds of religion, race or language. This is their own right. So in the first provision of Article 29, that is for the section of citizens, that is for whole community, but the second provision provides for the rights of individuals, and here it is for minorities. But the Supreme Court said that there is written as section of citizens, that can be minority as well as majority. Because there is written as section of citizens, it is not written as minorities. So these rights can be for minorities as well as majorities, but these are considered as the interests of minority. So Article 29 is for providing the interests of minorities, you can say that. And next is right of minorities to establish and administer educational institutions. Right of minorities to establish and administer any educational institutions. So Article 30 provides to minorities the right to minorities that they have right to administer and to establish and administer those educational institutions. They have right to establish and administer those educational institutions, and they have right, there can be three types of educational institutions that are owned by minorities, because these rights are given only to the minorities. Here it is written as minorities, not as section of state. So it is only for minorities, and there can be three types of educational institutions according with Article 30, and those are, first is that educational institutions that are receiving recognition as well as aid from the state. Second can be that are receiving recognition from the state but not aid, and third are that institutions that are neither receiving recognition nor aid. And first and second that are receiving recognition or aid have right, don't have right for prescribing syllabus, because the state will prescribe syllabus, discipline, appointment of teachers and non-staff, you can say that non-teaching staffs. So in first and second the states have right, you can say that, to administer that school, but in the third it is a duty of those owners, it is a duty of the minorities that have established that school to prescribe syllabus, for discipline in that school, for equipments in that school, for appointments of teacher staffs as well as non-teaching staffs. So Article 30 is for minorities, particularly minorities, and in the judgment of Supreme Court of the Secretary Malankara Catholic College case, it was that they have summarized of the minorities established and administered educational institutions. Supreme Court held that minorities have right to establish and administer schools, educational institutions. That means they have right to establish and administer by appointing teachers, non-teaching staffs. They have right for equipments, and these rights are conferred to minorities. It is not for that they will become more advantageous. It is because there will be equality, because you can say that they are behind the mean social class, mean society. So for this, these rights, these privileges are conferred, but they are all matters. The general classes, social welfare, public order, morality, health, sanitation are instituted, are conferred, are subjected to all educational institutions, including minorities educational institutions as well. So Article Article 30 is providing for the minorities for the establishment and administering of educational institutions, but they are also subjected to state for the national, for social welfare, for national security, for public order. They are subjected to all institutions equally. In those cases they are not privileged. So Article 29 and Article 30 are for minorities in precisely, you can say, and that's why it is cultural and educational rights. So our next fundamental right is right to constitutional remedies. Right to constitutional remedies, that is our sixth and last fundamental right. Right to constitutional remedies, that covers Article 32 and says that it is for remedies. If any of the fundamental right is violated, then Article 32 protects it. Article 32 is to protect every fundamental right that are conferred to citizens of India. In other words, Article 32, that is right to move Supreme Court in case if and when fundamental rights are violated. If any aggrieved person, that's fundamental right is violated, can go directly to the Supreme Court, not by the way of appeal. You can say that Article 32 is for that right to move in Supreme Court, and Article 32 provides 4 provisions that are: first is that right to move to Supreme Court not by the way of appeal. It depends on the person. He can go directly to the Supreme Court or by way of appeal if and when fundamental rights are violated. Second is that Supreme Court shall have the power to issue writs in case of violation of fundamental rights, and those writs are those: habeas corpus, mandamus, certiorari, prohibition, quo warranto. These are the writs that can be issued by Supreme Court in case of violation of fundamental rights. And third is that Parliament shall have power to issue any other court to issue order, to issue writs, and those any other courts doesn't include High Court, because High Court has also right to issue writs under Article 226, and Supreme Court has right to confer to issue writs under Article 32. So Parliament has power to give order another court. It can issue any other court to issue any order and or any writs. And fourth is that the right to move directly to the Supreme Court and right to issue writs by the Supreme Court cannot be suspended, but it can be suspended only during the time of national emergency. In other words, only the president can suspend them during the time of national emergency. So these are 4 provisions under Article 32, and the Supreme Court is guarantor and defender of fundamental rights as well, because the Supreme Court is responsible for enforcement of those rights. Because if there is no enforcement of fundamental rights, then what has person to do? He has to go to the Supreme Court, not by the way of appeal. It depends on him. So he can go directly to the Supreme Court, and Supreme Court for the enforcement of those fundamental rights can issue writs, and there are mainly 5 writs. And Supreme Court is original as well as wide. In original, you can say that in original in the way that it includes that any person go directly to the Supreme Court, and second is that it can issue writs. It can issue writs without any discrimination in case of violation of fundamental rights. And Dr. B.R. Ambedkar said that Article 32 is the most important article in our Constitution, because without it is not nullified to the fundamental rights. And Article 32 is only for the violation of fundamental rights, not for the violation of legal rights or non-fundamental rights or constitutional rights. If there is violation of those rights, then you have to go by the way of appeal, because Article 32 upholds only for the fundamental rights. And the Supreme Court said that if there is possibility of a good judgment in High Court or in any other court, then aggrieved person should go first to the High Courts, then Supreme Court. It is not necessary to go directly to the Supreme Court. So Article 32 is for protecting of all fundamental rights. In other words, in protecting the other fundamental rights, Article 32 is also a fundamental right, that is protecting other fundamental rights. So our next topic is writs, type and scope. Writs, type and scope. So the power of issuing writs has been conferred to Supreme Court under Article 32 and to High Courts under Article 226. Both courts, the Supreme Court and as well as High Courts of all states, have right to issue writs. And earlier, the High Courts, only the High Courts of Bombay, Calcutta and Madras had right to issue writs, but after 1950, it was given to all High Courts under Article 226, and these writs can be issued if there is a violation of fundamental rights. But however, the writs issued by Supreme Court, the power of issuing writs can be different of Supreme Court from High Courts in three ways, and those are: first is that the Supreme Court can issue writs only in the case of violation of fundamental rights, but the High Courts under Article 226 can issue writs on fundamental rights, on the violation of fundamental rights, as well as in other cases. In other cases means in legal rights, in violation of legal rights, constitutional rights or non-fundamental rights. So you can see that the power of issuing writs of High Courts to issue writs is broader than that of Supreme Court, because Supreme Court has right to issue writs only in the case of violation of fundamental rights. And second is that the Supreme Court has no right to refuse the exercise of issuing writs under Article 32, because Article 32 is also a fundamental right. So the Supreme Court has no right to refuse the exercise of issuing writs, but the High Courts have right. On the other hand, the High Courts have right to refuse the exercise of issuing writs under Article 226. So this is that there is a difference, is that the Supreme Court is guarantor and defender of the fundamental rights, so it cannot refuse to the exercise of issuing writs. And third is that Supreme Court has right to issue writs in case of enforcement of fundamental rights throughout the territory of India, in every part of India, throughout the territories of India. But on the other hand, High Courts have right to issue writs only in their territory, of jurisdiction, and they can issue writs in case of territorial jurisdiction. So you can say that the concept of issuing writs is broader of Supreme Court, is that Supreme Court can issue writs in throughout the territories of India, but High Courts have their limit to issue their writs. So these are three differences between the writs of issuing power of writs between Supreme Court and High Courts, and these writs are conferred under Article 32 and Article 226, and there is meaning of those writs. There are 5 writs, that are habeas corpus, mandamus, prohibition, certiorari and quo warranto. So let us understand their meanings. First is habeas corpus. Habeas corpus, so it is a Latin word, and its literally meaning is that to have the body of, and it is generally issued when a person claims detention to other person, and when that person is found that the detention was illegal, the person that has given detention to other person was illegal, then you can say that this habeas corpus is the bulwark of illegal detention, of protection of detention to the person, and it can be issued against the public offices as well as the private individuals, but it cannot be issued against the contempt of the court. If the detention is the contempt contempt of court, contempt of the legislatures, and if it is a legal detention, then it cannot be issued against these things. So habeas corpus, that means to have the body of, and it is when a person claims detention to other person, and when the survey, the research on that person has done, and it is found that the detention is illegal, then it is issued. And second is Mandamus. Mandamus, that is we command. The literal meaning of Mandamus is we command, and it is generally issued by courts to the other offices to tell them they have to perform their duties, to tell them, to ask them, to command them. The courts issue these rights, we command. They command to the offices to perform their duties that are they refusing to do, and it can be issued against public offices, but not against private individuals, and it cannot be issued, Mandamus writ cannot be issued against the President of India or the governor of states, or against if the duty is not mandatory. If the duty is not mandatory, then it cannot be. The writ of Mandamus cannot be issued, or it cannot be issued against the office that is not a statutory. It can be used against only of statutory office. Mandamus can used only in the Mandamus writs can be issued only in the case of statutory office, not in the case of non-statutory office. So Mandamus means we command, and generally it is to command to other offices, public offices, to perform their duty. And next is Prohibition. Prohibition, that generally means to forbid. The literal meaning of prohibition is to forbid, and it is generally issued, the writ of prohibition is generally issued to stop the other public office to stop their duties, that is they are performing error, they are using their power against the limit, up above the limit. If they are using their duties unnecessarily, that is that there was no use of them and they were using their power above the limit, then it could be used. The issue of writs, the writs of prohibition is issued to a public office when that public office is reaching above the limit, that is to their powers, the assumption of their powers. So it is prohibition, to forbid. In the Mandamus, the issue of Mandamus writs is for that activity, you have to do their activity, but in this it is inactivity, that is to prevent them usurping their limit. And next is certiorari. Certiorari, it is that to be certified or to be informed, and it is issued by a higher court to a lower court to squash their judgment, to squash that lower court's judgment, or to prevent them. Because in the case of prohibition, it was that you are preventing that public office to do their activities, that they are usurping their power, but in this case you are stopping them. You have prevented them and then you are stopping them. So the certiorari writ is for that when the power, the jurisdiction of the court, to squash that jurisdiction of the court, or you can say that it can be used against judicial or quasi-judicial authorities. It cannot be used against administrative services, legislatures. So you can say that the certiorari, that is to be certified or to be informed, is for that to stop their uses, to stop their duties that they have done above their limit, that was not their work but still they had done. And next is quo warranto. Quo warranto, that is to be ward of by warrant. Its literal meaning is that to be ward of by warrant. That means when a person claim that a public office to be its own, that is, a person is claiming as the owner of a public office. So for this, quo warranto writ is issued to check whether it is legal or illegal. So for this, the quo warranto can be sought by an interested person. It is not necessary that as always an aggrieved person came. So the quo warranto is for that whenever a person claim a public office to check whether that is legal or illegal, quo warranto writ is issued. So these are 5 writs that are habeas corpus, mandamus, prohibition, certiorari and quo warranto, and these all 5 have their literal meaning, and they were brought up by England. First they were started in England and they were named as prerogative writs. So next topic is armed forces and fundamental rights. Armed forces and fundamental rights. So till now we had discussed Article 32 and now comes the Article 33. As in the starting of this chapter I had said that fundamental rights are under Part 3 of the Constitution and cover from Article 12 to 35. But this Article 33 doesn't provide any fundamental right, but it is related to the fundamental rights. So Article 33 empowers Parliament to restrict the application of fundamental rights to the members of paramilitary forces, analogous services, intelligence services, agencies or police forces, armed forces. So in other words, the application of all fundamental rights are restricted on those, and any law can be enacted, any act or any law can be made enacted by the Parliament, only by the Parliament, not by the state legislature, to bring the uniformity in those laws of fundamental rights. So Parliament can enact or can make laws or acts in the restriction of the application of fundamental right to member of these forces, and those laws cannot be connected, cannot be contravened, cannot be challenged in any courts, and as in the part of the contravention of fundamental rights. Parliament has right, Parliament has been empowered to make those laws, and those laws cannot be challenged in any court. And accordingly, Parliament has enacted many laws. For example, the Army laws, the Army Act 1950, the Navy Act 1950, the Air Force Act 1950, the paramilitary forces. These are all, there are many acts that are enacted by the Parliament to restrict the application to the members of these agencies, these forces, and the members of these agencies, these forces, for example, armed forces, police forces, also include, for example, those are related to those, for example, carpenters, tailors, cook, mechanics. Those are non-combatants, those are in those services but are not doing the work directly, and this is because these are restricted. The application of fundamentals, the fundamental rights is restricted on these agencies, these forces, to bring discipline among them. And those rights, for example, like the right to speech and expression, right to form trades or unions, right to do demonstration, are all etc. All rights are restricted to these agencies, these forces, to members of these forces. And Parliament can prevent the martial law under the writ from the writs of Supreme Court and High Courts, so far as fundamental rights are concerned. So far concerned for the fundamental rights. So Article 33 is for the relation of armed forces and fundamental rights. There is no fundamental right that are conferred to armed forces, paramilitary forces, analogous services, intelligence agencies, all these things. So after completing armed forces and fundamental right, next topic is martial law and fundamental rights. Martial law and fundamental rights. So armed forces was Article 33. Now comes Article 34 that provides for restrictions in area where there is martial law. That means in any part of India, if there is martial law in that area, that means there will be restrictions on fundamental rights. And martial law means military rule. Military rule in its literal meaning, and it is derived from English common law. But martial law has not been defined in anywhere in constitution or in any amendment. It has been only meant as military rule after deriving from English common law in its literal meaning. And whenever there is military rule, martial law in any part of India, then all the authorities goes to military authorities. All the power to administer that area goes to military authorities. And during the period of martial law, there are abnormal powers that are occupied by military authorities, that are given to military authorities. Military authorities have so much abnormal powers during the time of martial law. And martial law is placed on any area because to restore any law, to restore the order of law. So to restore the order of law during the time of invasion, during the time of insurrection, during the time of war, there can be martial law in parts of India. And during the military rule, during martial law, the military authorities have abnormal powers and they can do anything in order to restore the order of law. They can even condemn to death to any person. And Article 34 empowers the Parliament to indemnify any person or government official for any act done by him when there was military rule, when there was martial law. So Article 34 is for that restrictions on fundamental right during martial law and to empower Parliament to indemnify any person or government official for any act done by him in military rule during the time of martial law. And during martial law, abnormal powers has been occupied by military authorities and they can do anything. But there is difference between martial law and national emergency. During the time of national emergency, you know that there is no there would be restrictions of fundamental rights, as well as there would be some kind of hassle in the relation of center and state level. But during the time of martial law, there would be only restrictions on fundamental rights. And during the time of martial law, there would be no any ordinary law. The all administration would be done by military authorities according their law. According their law, they can make any law. But during the time of national emergency, the ordinary laws are continued. They are not repealed, curtailed, or any restriction placed on them. And martial law is imposed in a territory of India, in a part of India, while national emergency is placed rather in the whole country or in parts of India. In part of India, it can be in the whole part or it can be in parts of India as well. And military and martial law can be imposed only at the time to restore the order of law, but national emergency can only be imposed at the time of war, at the time of invasion, at the time of external aggression, at the time of armed rebellion. So there is difference between martial law and national emergency. The conditions, the situations are not same during the martial law and national emergency. And martial law is implicit in Article 34. There is no confine, there is no depth, there is no provision for martial law in any part of the Constitution. Whereas for the national emergency, it is been defined, it has provision in Article 352. So Article 34, martial law is implicit in the Constitution, whereas national emergency is explicit in the Constitution. So Article 34 is for the martial law, the relation between martial law and fundamental rights. So our next topic is effecting certain fundamental rights. So So till we have discussed Article 34. Now comes Article 35 that empowers Parliament to make laws, for making laws to enforce, to effecting certain fundamental rights. Now Article 35 provides for four provisions, and those four provisions are only for Parliament. Only Parliament can make laws, not state legislature, for effecting the fundamental rights, to bring the uniformity to the nature of fundamental rights. That's why only the Parliament has right to make laws in order to effect fundamental rights. That's why to bring uniformity into the nature of fundamental rights. And Article 35, in Article 35 there are four provisions that are Parliament has been empowered to prescribe any residence or for the appointment or for the employment of any union territory, of any territory, or on any authority, local authority of India. It can prescribe residence as for employment in any part of India. Now second provision of Article 35 is that Parliament has right. Parliament can make laws, can restrict or abrogate the application of fundamental rights to the members of paramilitary forces, to the armed forces, to the members of armed forces, to the members of intelligence services, to the members of analogous services. So Parliament has been empowered. Now the third provision of Article 34 is that Parliament has been empowered to prescribe, to empower any other court other than High Courts and Supreme Court to issue writs and orders for the enforcement of fundamental rights. And fourth provision of Parliament is that of Article 34 is that Parliament has been empowered to indemnify any government servant or any other person for any act done by him when there was martial law. So these are four provisions of first part of Article 34. Now the second part of Article 34 says that only Parliament and not the state legislatures can make laws for the offence done under the fundamental rights. You know that in fundamental rights, untouchability, holding titles, holding hereditary titles are considered as an offence. So for those offence, specified laws for their punishment can be made only by Parliament and not by the state legislature. And the third is that only Parliament can curtail or repeal them. Those laws have to be continued until they are curtailed or repealed by the Parliament, not by the state legislatures. So Article 34 is that Parliament, only the Parliament and not the state legislatures has right to make laws for giving effect to certain fundamental rights. So next topic is present position of right to property. Present position of right to property. So till now we have discussed the fundamental rights. As you know, right to property was a fundamental right, now it is a fundamental right. It was earlier a fundamental right of citizens or non-citizens for both, but it was deleted by the 44th Constitutional Amendment Act of 1978. It was repealed by that Amendment Act. And during that, when there was right to property as a fundamental right, there were two provisions. There were two articles related to right property. They were, first was that Article 19(1)(f) that provided to every citizen to acquire, to hold or to dispose of any property, and Article 31 that was right to property, that was every citizen has right for the protection against the deprivation of his property except the government, except the authority, and authority could take property of that person only in two conditions. That were, first was that it should be for public purpose. Government could take property only for the public purpose, and second that it had to pay compensation or amount to the owner of that property. So these were two conditions for acquiring the property of any person under right to property as a fundamental right. As you know that for right to property there had been so many conflicts between Supreme Court and Parliament. There had been so many hassle in our polity between Supreme Court and Parliament, and in order to nullify the right to property there had been so many amendments in right to property, like 1st, 7th, 25th, 42nd. There had been so many amendments, and finally by the 44th Constitution Amendment Act it was repealed, it was curtailed, it was deleted by the 44th. Because of it, because of the right to property, there had been so many conflicts, there had been so many controversies between Supreme Court and Parliament, because Parliament didn't want to pay compensation. It had controversial. Parliament said that Parliament held that the right that the government had to pay compensation was controversial. So for this, by the 44th Constitution Amendment Act of 1978, the right to property was curtailed, and after that right to property is a legal right, is a non-fundamental right under Article 300, under Part 12th of our Constitution, of our Indian Constitution. Now it is a right, as right to property, it is that no person should be deprived of his property, except by authority, except by government. And even if government took that property, it doesn't have to pay compensation for it, and it is a legal right. That is, the right to property at present time, it is just a legal right. It can be curtailed or repealed by an ordinary law. There is no need of amendment acts to curtail this right, or it can be abrogated as well. And in case of violation, the aggrieved person can go to the High Court. By the way of appeal, he can go Supreme Court. He cannot go directly to the Supreme Court. He has to go to Supreme Court by the way of appealing. So first he has to go for High Courts and then Supreme Courts. So you can say that right to property is just a legal right, but however government cannot take the property of the minor education institutions of minorities of India. If it is a property, if that property which government wants to acquire is of a minority, then it cannot take. And there is second provision as well to take property again according to right to property as a legal right. It is a legal right. So first is that government cannot take the property of a minority, and second is that government cannot take a property that isn't permanent of sealing. That is, it isn't permanent, it is of that person's own sealing, of own permanent sealing, then government cannot take that property. So government cannot take properties, cannot acquire any property under these two conditions. And if it takes, the government has to pay compensation if it takes the property of minorities or a property that is on a permanent sealing, that is in an own cultivation of that person. So if government take that property, then it has to pay compensation, otherwise not. So our next topic is exceptions to fundamental rights. Exceptions to fundamental rights. Now which rights are called as exceptions to fundamental rights? Article 31A, Article 31B and Article 31C are called as exceptions to fundamental rights. Now Article 31A, B, C, these were under right to property and were deleted, were repealed by the 44th Constitutional Amendment Act of 1978, and after that they are called as exceptions to property, exceptions to fundamental rights. So our subtopic is saving of laws providing for acquisition of estates, etc. Saving of laws providing for acquisition of estates, etc. Now this is Article 31A that provides saving of 5 particular laws that cannot be invalidated or cannot be challenged on the basis of contravention of fundamental rights under Article 14 and Article 19 in any courts. Now Article 14, as you know, is for equality before law and protection and equal protection of laws, and Article 19, as you know, that protection of 6 rights. Now Article 31A that provides for saving of 5 particular laws cannot be challenged in any court on contravention of these rights, and those 5 rights that are saving for laws that come under Article 31A are related to agriculture, land, reform, properties, and those 5 rights are: first is that acquisition of states and rights to manage them. Second is that management of properties by state. Third is that amalgamation of corporations. Fourth is that extinguishment or modification of rights of shareholders or directors, board directors of corporations, of authorities, of companies. And fifth and last is that extinguishment or modification in mining leases. So these 5 are the saving laws that are saved by Article 31A and cannot be challenged in any court on the contravention of Article 14, fundamental rights guaranteed by Article 14 and Article 19. So this is saving for laws for the acquisition of estates that the state is acquiring, state can acquire, and for saving that. So next topic is validation of certain acts and regulations. Validation of certain acts and regulations. Now we have discussed Article 31A. Now comes Article 31B, that is validation of certain acts and regulations. So Article 31B provides that all acts and regulations that are included in the 9th schedule of our Indian Constitution cannot be challenged on the contravention of fundamental rights under Article 14 or Article 19. Now all these acts, regulations cannot be challenged. It was in this right, it was in this article 31B. So the scope of Article 31B is bigger, is expanded, is extended, is greater than of Article 31A, because Article 31A provided of saving of laws, validation of particular 5 laws, but this is for all acts and regulations included in 9th schedule of our Indian Constitution. But the Supreme Court in the famous E.R. Coelho case of 2007 ruled that the judicial review of our Supreme Court cannot be taken away, because it's a basic structure of our Constitution, so it cannot be taken away by regulations or acts by imposing just an article. So it said that Supreme Court held that any regulations or acts that were included in 9th schedule of our Constitution after 24th April 1973 can be challenged, had to cooperate with Supreme Court. They can be challenged in Supreme Court. And now 24th April 1973, because on this day, on 24th April 1973, it was that the concept of basic structure, basic features of Constitution was brought up by Supreme Court in famous historical case, Chauhan and Bharti case of 1973. So in Chauhan and Bharti case of 1973, on 24th April 1973, Supreme Court ruled that their preamble is a part of Constitution, and second most important, it included the basic structure, the concept of basic structure of the Constitution was brought up. So it said that in the 2007 case, in E.R. Coelho case, Supreme Court held that any laws, any regulations, any acts in the 9th schedule of our Constitution that were included after 24th April 1973 can be challenged in courts, in Supreme Court, in any courts on the contravention of fundamental rights or for destroying any basic structure of the Constitution. So next subtopic is saving of laws giving effect to certain directive principles. Saving of laws giving effect to certain directive principles, that is Article 31C. It was inserted by the 25th Constitutional Amendment Act of 1971, and it contained 2 provisions that were: first was that in this Article 31C, the first provision was that no laws seek to be implemented for the directive principles contained in Article 39B or C shall be void on the contravention of the fundamental rights guaranteed by Article 14 and Article 19. So this is the first provision of this Article 31C, and the second provision of Article 31C is that no laws, no such policy can be challenged on the contravention, cannot be challenged in Supreme Court in any courts that it is for that policy, it is for that work. So if any such policy is made, it cannot be challenged in any courts as for that it is made for that purpose. But the Supreme Court held that the second provision of this Article 31C is unconstitutional, because no one can take the judicial review of Supreme Court as it is a basic structure of the Constitution. And it said that it held that Supreme Court held that the first provision is constitutional, is valid, but not the second one, because it is taking the judicial review of Supreme Court, and that is the basic structure of the Constitution. So it said that the second provision of Article 31C is unconstitutional and void, it is invalid, and first is valid and constitutional. Now first provision of Article 31C says for that the laws seek to implement the directive principle contained in Article 39B or C, but by the 44th Constitutional Amendment Act of 1976, Supreme Court extended its scope. In the sense that it said that Supreme Court said that after 42nd Constitutional Amendment Act of 1976, it was that the power, no law seeks to implement the whole directive principles. It was not that merely in Article 39B or C, it was for the whole directive principles. It was extended for the whole directive principles that no laws seek to implement for the implementation for the policies of article for the whole directive principles. Earlier it was Article 39B or C, but now after the 42nd Constitutional Amendment Act of 1976, it was extended to the whole directive principle state policy. But after that, after the Minerva Mills case of 1980, it was considered, it was repealed, it was void, it was declared as void by Supreme Court. So now at present time under Article 31C is that only for 39B, Article 39B or C. So this is right to property. These three rights were under right to property and were repealed by the 44th Constitutional Amendment Act of 1978. So next topic is criticism of fundamental rights. Criticism of fundamental rights. So as we know that fundamental rights are enshrined in Part 3 of our Indian Constitution, and they have been criticized in many ways, that critics have opined in many ways for the criticism of fundamental rights, and those are: first is excessive limitations. That is, the critics said that critics have declared that the fundamental rights are placing so much limitations on the persons, on the citizens. And the Jaspat Roy Kapoor said that the chapter which is for the fundamental rights, which is explaining fundamental right, should be designated as limitations on fundamental rights or limited fundamental rights. So it is a criticism of fundamental rights that there is excessive limitations, as there are so many rights that have limitations on them. So this is the first criticism on the basis of excessive limitations. And second is no social and economic rights. No social and economic rights. That is, it is mean the fundamental rights have been criticized that they are only for political rights. There have been no social or economic rights like right to leisure, right to employment. These are all the social and economic rights, and these are not guaranteed by fundamental rights, and only the political rights are guaranteed, not the social and economic rights. So the fundamental rights is also criticized in this way as the no social and economic rights. Now third is no clarity. It is that the fundamental rights have been criticized as there is no clarity in them. There are many terms which have not been defined in constitutions, in fundamental rights, mainly the part 3 in any constitution, in our constitution, and there have been so many terms like reasonable restrictions, public order, minority. These are the terms. There are so many terms that have not been defined in constitution. So it is said that critics have criticized that there is no clarity in our fundamental rights, and Ivor Jennings said that this is because there is no clarity because the language of fundamental rights is so complicated, because these were made by lawyers. As Sir Ivor Jennings declared the Indian Constitution, set the Indian Constitution as paradise of lawyers. So you can say that no clarity is also been a method, is also been a way, is also been criticized. Fundamental rights has been criticized on no clarity. Now next is no permanency. So the fundamental rights have also been criticized that they are not permanent, they are not sacrosanct, as they can be curtailed or repealed by an amendment act. And also the Supreme Court has brought only the doctrine of basic structure, and there are only few rights, but the fundamental rights should be permanent. The opinions of critics is that the fundamental rights should be permanent. They cannot be curtailed or repealed even by an amendment act. They should not be curtailed or repealed. So another way in which fundamental rights have been criticized is that there are no permanency for fundamental rights. Now next is suspension during emergency. Suspension during emergency. So as you know, during the period of national emergency, the fundamental rights are not guaranteed to persons, to people, except Article 20 and 21. So the opinions of critics is that there should be fundamental rights guaranteed to persons, people, every time, whether there is emergency or not. So that is, the fundamental rights have been criticized because they are suspended. There has been imposed restrictions on them during the time of emergency. That should not be in the views of critics. Now next is expensive remedy. That is that you know that whenever there is violation of fundamental rights, now aggrieved person has to go Supreme Court, to the Supreme Court directly he can go, but there is so much expenditures for that, for occupying that remedy of Supreme Court. There is so much expenditure. So the criticism is that the fundamental rights are guaranteed, the remedies are guaranteed only to the rich person, because for a common man it is not possible for that expensive remedy. Now next is preventive detention. So as you know, under Article 22 there is preventive detention. The provision of preventive detention is in Article 22 of our Constitution, and as you know, the provision of preventive detention is only in Indian Constitution. It is not in any democratic country's constitution. So critics have criticized fundamental rights that there should not be provisions of preventive detention. The criticism is that after reading, after studying preventive detention, it is that these are right to state against individuals, not the right to individuals against states. So the criticism is that the preventive detention is giving rights to state against individuals, not to individuals against state. Now next is no consistent philosophy. So it is said that critics criticize the fundamental rights that our fundamental rights are not consistent. There is no consistency. There is no consistent philosophy. Sir Ivor Jennings said that Indian Constitution, that the fundamental rights are not consistent as they are. They are not comprehensive that they should be. So it is said that critics have criticized. Criticism is that no consistent philosophy. There have been no consistency of philosophies. So next topic is significance of fundamental rights. Significance of fundamental rights. So in spite of these all criticism that we have discussed, there are so much significance of our fundamental rights. There are so many significance on these ways that they constitute to the bedrock of the democratic system in country. They provide for the establishment of rule of law in our country. As you know that fundamental rights also establish the rule of law in our country. They uphold the fundamental rights, uphold the integrity and unity of nation as well as liberty, personal liberty of person. They also uphold the dignity of individuals. The fundamental rights uphold the dignity, the liberty, the choices of person, of every citizen, of every person. So fundamental rights are of great significance. There is so much importance of them, and they are very crucial for any country. They are very crucial for the establishment of democratic system in our country. And fundamental rights are also for the public political administration as well, and they constitute, as you know that they constitute to the rights of the citizens. They constitute the basic needs, basic rights of the citizens, and they also make the bedrock of the constitution of our country. So next topic is rights outside part 3. Rights outside part 3. So till now in the whole chapter we have discussed the rights that are included in the part 3 of the constitution and are called as fundamental rights. But in an Indian constitution there have been so many rights outside the part 3 as well, and they are called as legal rights or constitutional rights or non-fundamental rights. And there are many rights are those, and they are not justiciable. They can be curtailed or repealed. There can be restrictions on them by just in ordinary laws. So some of the laws, some of the rights, legal rights are that no tax shall be levied above the limitations, and second is that every person has right for the protection against the deprivation of his property except by authority of law. And third is that trade, commerce or intercourse throughout the territory of India, under the territories of India shall be free. That shall be free. All trade, commerce, intercourse in India shall be free. So these are some legal rights, constitutional rights, non-fundamental rights as well, you can say that. And they are justiciable, but you cannot go, the aggrieved person cannot go directly to the Supreme Court for the issuing of writs. They have to go by the way of appeal. They have to go first High Courts and then Supreme Courts. And the legal rights can be curtailed or repealed even just by an ordinary law. There is no need of Amendment Act. So fundamental rights are guaranteed to every person and cannot be curtailed, and can be curtailed only by Amendment Act but cannot be curtailed by an ordinary law. And even an Amendment Act can curtail only the rights that are outside the basic structure of the Constitution. So this is all about this chapter. We have discussed fundamental rights from Articles 12 to Article 35, in which we had seen that earlier there were 7 fundamental rights, and now at present time there are 6 fundamental rights, only 6 fundamental rights. And we have seen that the Article 12, 13 are not fundamental rights but are related to fundamental rights as well, goes for the Article 33, Article 34 and Article 35 as well. So this is all about the chapter. We have discussed in depth about the fundamental rights. From our first fundamental right to 6th fundamental right, we have discussed all articles, their subparts as well. And fundamental rights, the fundamental rights are, you can say that, are the recognizing are the identity of our constitution as well. You can say that because these are the basic needs, basic rights of every citizen. They are not conferred to every person. Some are available only to the citizens and some are available to citizens as well as foreigners. But even in foreigners, there are rights that are not guaranteed to enemy aliens. They enjoy less rights than those of friendly aliens. So this is all about the chapter. I have discussed all topics and subtopics from article 12 to article 35, and this is our chapter. This chapter is completed. Now this is the last part of this chapter. In the first part we had discussed, and this is the second part of this chapter and last part as well. So this is all about the chapter. I have discussed all topics and subtopics, and I'll be covering next chapters in further videos. So thank you very much.